Grant Cardone has built one of the largest personal brands in real estate history by speaking directly to ordinary people online. But those same Instagram and YouTube promotions are now the center of a certified federal securities class action lawsuit. A jury trial is currently scheduled for March 9th of 2027. But before we get into the claims, we need to separate the actual court record from the internet version of this case. You see, no court has found that Cardone committed some fraud. No court has found that he stole investor money, and the public record does not show that the named investor was actually wiped out. The defendants deny making any materially false or misleading statements and deny violating federal securities law altogether. The claims that survive the federal class action are pretty narrow, actually, and legally they're much more interesting. They concern a projected 15% return, a public SEC staff comment letter, expected distributions, and a social media statement about who was responsible for the debt. The story begins with Luis Pino, a California retail investor. According to the complaint, Pino attended one of Grant Cardone's Breakthrough Wealth Summits in Anaheim, California on September 21st, 2019. 2 days later, he invested $5,000 in Cardone Equity Fund 5. On November 15th, he invested another $5,000 in Fund 6, $10,000 in total. Fund 5 and Fund 6 pooled money from investors to acquire large real estate assets. They were offered under Regulation A, which is a framework that permits certain public securities offerings, including sales to people who do not satisfy the SEC-accredited investor standards. Pino filed suit in September of 2020. He died in February of 2023 before the case was ever resolved. His daughter, the successor in interest, Christine Pino, continued the lawsuit and was later appointed the class representative. Now, the legal theory matters here, guys. This is a securities Section 12A2 case. In simplified terms, that provision can allow a buyer to seek rescission when a security is offered or sold through a prospectus or oral communication containing a material misstatement or omission. If a current holder ultimately wins and elects rescission, the remedy can involve tendering investment in exchange for the purchase consideration plus statutory interest, less income already received. The official class notice emphasizes that no investor will be forced to give up an investment merely because the case exists. It is therefore not simply a claim that an account went to zero. It is a claim that the investments were marketed through legally actionable statements or omissions. Now, the most prominent surviving theory concerns the projected returns and distributions. The Ninth Circuit's 2025 opinion quotes a YouTube statement by Cardone. The Ninth Circuit is the Court of Appeals for the federal government that involves the California case. Now, they quoted in their opinions, quote, "You're going to walk away with a 15% annualized return. If I'm in that deal for 10 years, you're going to earn 150%. You can tell the SEC that's what I said it would be. Some people call me Nostradamus because I'm predicting the future, dude. This is what's going to happen." The opinion also describes Instagram promotions saying investors could double their money. The defendants have disputed these statements create liability. Their position includes arguments about opinions, forward-looking projections, context, and the risk disclosures in the formal offering materials. And that is an important defense side point. Real estate projections are not guarantees merely because somebody said them confidently. Formal offering documents can contain extensive warnings about market conditions, leverage, operations, and the possibility that investors are going to receive less than the projected amount. But Pino's case focuses on whether the specific social media statements were misleading in context, especially because of an earlier SEC staff letter. On July 30th, 2018, the SEC staff sent Cardone a comment letter while reviewing Fund 5 draft offering statements. Comment 2 noted that the filing referred to a strategy designed to produce an approximately 15% annualized return through monthly distributions. The staff wrote that Fund 5 had commenced only limited operations, has not paid out any distributions, did not appear to have a basis for that return. It then asked the issuer to remove the disclosure from the offering statement altogether. Precision is essentially here. This letter was not an SEC fraud finding. It was not a court order, and it did not say Cardone was forbidden from forever discussing the projections anywhere. It was a staff comment on the formal filing. Cardone removed the projection from that filing, and Pino alleges that he later repeatedly compared return and distribution projections on social media, and he never disclosed this SEC comment. The Ninth Circuit Court of Appeals did not decide that the allegations were true. Reviewing a motion to dismiss, the court had accepted the complaint's factual allegations as true, and they drew reasonable inferences in favor of Pino. Under the limited standard, the panel held that Pino plausibly alleged both that the projected returns were objectively untrue when made and that Cardone did not genuinely believe it. The panel also held that the omitting the SEC letter from the particular social media communication plausibly supports an omission claim, even though the letter itself was publicly available on the SEC's website. That is what's called a pleading stage ruling. It's not a verdict. The defendants can contest the evidence, the interference, the materiality, the causation, and any available defenses as the case proceeds. The other surviving statement is shorter. In an Instagram post, Cardone said specifically, "One question you might want to ask is, who is responsible for the debt? The answer is Grant." Pino alleges this materially misstates who bore the fund's debt obligations. Why does that matter? The Ninth Circuit reasoned that if Cardone personally were responsible for the debt, there could be fewer costs for the investors and potentially higher returns. That could affect the information a reasonable investor considers important. Again, the appellate court did not resolve the factual dispute. It held that Pino alleged enough for the debt theory to continue beyond dismissal. Now, the procedural history in this case is actually unusual. The district court dismissed the case in 2021. The Ninth Circuit then ruled that mass Instagram and YouTube communications can qualify as solicitation under Section 12A2 and it revived the return, distribution, and debt theories while leaving the other theories dismissed. Now, after Pino amended the complaint, the district court dismissed it again in 2023. In June of 2025, the Ninth Circuit reversed it again, holding that the repleted allegations were sufficient to proceed. Then you see on March 27, 2026, the district court certified a class covering qualifying purchasers of interest in Fund 5 and Fund 6 through public offerings. Class certification is not a finding of liability. It means the court found the procedural requirements satisfied for the defined investors to litigate their surviving claims altogether. The question most viewers will ask, what happened to Luis Pino's $10,000? The most accurate answer is the public record does not show that Pino's received their full $10,000 back in cash, and it does not establish that they lost their $10,000 either. A 2021 district court order described a January 2021 investor portal image as reflecting Pino's full initial investment in both capital accounts. That is not the same as a cash redemption. It is evidence of an accounting interest remaining in the fund at that time. The public fund filings also report Class A cash distributions. Through June 30th, 2025, Fund 5 reported a cumulative Class A distribution equal to about 28.7 cents per original dollar of Class A capital. For Fund 6, they reported about 25 cents per original dollar. Pino's two $5,000 investment interests had participated exactly in those fund-wide averages from inception. The arithmetic would illustrate approximately $1,436 from Fund 5, $1,250 from Fund 6, about $2,685 in cash distributions. But that is not a verified Pino-specific number. His subscription timing could affect those results. His private distribution statements are not public. The same filing reported positive Class A net asset value, or NAV, as of June 30th, 2025. On the same simple pro rata illustration, the two interests would correspond to approximately $15,592 in reported NAV. And the illustrative distributions and the combined cash plus reported NAV figure would be roughly $18,278 on the original $10,000 investment. Do not mistake that, though, for a guaranteed payout. The filings describe significant level 3 valuation inputs, meaning estimates for assets without readily observable market prices. The reported NAV is not a stock market quote, a redemption offer, or the proceeds of a contemplated sale of any of the properties. So the final economic result, depending on what properties sell for, how much debt and obligations are paid, what cash remains from the investors, the class certification order itself notes that actual investment IRR cannot be determined until the business plan concludes and the relevant cash flows are realized. So the candid conclusion is this, guys. The principal appears to have remained tied to illiquid fund interests. Partial distributions were likely paid out. The fund later reported positive unrealized value. The exact Pino cash history and final realized gain or losses are not established in the public record. As of July 24, 2026, the official class website says the court has not decided whether Pino or other defendants are correct. The jury trial is scheduled for March 9th of 2027, although court dates can obviously change. Now, guys, the defendants obviously deny the allegations, including deny that they made any material false or misleading statements or omissions in violation of the federal securities law. Pino still has to prove that claim in a court of law in front of a jury. So the takeaway is not that Grant Cardone allegedly been found guilty of anything. He has not. The legally important takeaways is that securities rules do not stop at the four corners of the formal offering documents. That's important. The Ninth Circuit has held broadly that distributed social media communications can qualify as solicitations. It has also held, at least at the pleading stage here, that truthful information available elsewhere may not automatically cure an allegedly misleading omission in the specific communication being challenged. So for investors, the lesson is simple. Compare every promotional statement with the formal filings, the risk factors, the debt structure, and the actual distribution history. For influencers out there selling securities, the lesson is just as direct. Instagram confidence does not exist in a separate legal universe. The case now turns from allegations and pleading standards towards evidence. When that evidence is tested through dispositive motions, trial, or settlement, we will finally know whether Pino can prove the surviving claims. If you want the next docket update when it happens, make sure to subscribe subscribe to this channel. If you found this useful, share it with some of your friends who have seen the headlines but may not understand the court documents. Let's go.